the nature of the meeting, and that, my lord, would be ordinary in that realm of operation. Yes. My lord, the purpose of the proceedings before you is to get to the bottom of what happened with the second to the seventh petitions. Yes. My lord, I seek the opportunity on behalf of the ninth respondent, the first, second, and third respondents, yes, to be given the opportunity, my lord, to record statements from those petitioners who are confirmed to be at liberty. Yes. My lord, my clients may very well acquire leads during this process of statement taking. Yes. That may lead to the discovery of the whereabouts of the seventh petition. Yes. So, my lord, the request I make of you this afternoon is, for the reasons that I have placed before you, to kindly excuse the attendance of the Inspector General of Police before you this afternoon. And, my lord, the reason for his absence is, as I have stated, I wish to affirm on his behalf that he does indeed take and orders of this court very seriously. And, my lord, I request that by my clients to take place and be concluded after 14 days. Find out the whereabouts of the seventh petition. My lord, the proceedings before you are about liberty, and my clients believe they have very useful information of this matter. My lord, this is a serious matter. Yes. Seriousness that it deserves. I'm most obliged.
My name is Milimani.
Yes.
For the fifth respondent. Not with humility, I presentation for the fifth respondent, where nearly about 40% of the submissions that were going on, and kindly be able to proceed. Even without participating, they can be here so that they can be of help to me as I present issues pertaining to the fifth respondent. Thank you.
Council, but please impress on your colleague to be on the desk. During the recess, I had opportunity to thinking the absolute worst. Now that they're seeing the second to the sixth at liberty petitioner. I've heard Mr. Nimodi, I've heard you, Mr. Nimodi. From council is a proposal, not from Mr. Nimodi, from the rest. I'll begin. Second and third respondents in particular, the opportunity to take statements at two pauses. There can be no doubt. If the Inspector General of Police misses on that third, I will convict and invite him for hearing. So I'll begin with perhaps Senior Counsel Kalonzo.
Thank you.
Question, my learned friend. we suggest that one day to take these witness statements, whatever statements, is good enough. And so that your orders are taken seriously. We urge that you consider these your three options for now, and so that BC, first of all, Senator Mtata, I gather, was going to have another session Thursday, tomorrow,
yes,
for demonstrations.
the mother of all them.
And therefore, the pressure continuing will produce a seven, carry the wrong person. And it is not that it's demeaning her to make appearance a day before Mr. Kanja was sworn in and the release. Indeed, indeed, my lord, I must thank you for that. The gravity of this whole matter, and therefore I'm not going to talk about gangsterism, but I will insist so that the rule of law in this country would be seen to prevail. I thank you.
Therefore, we thank you, my Lord, for focusing on what is most important, to ensure that it is sufficient. I think that's what we have agreed with the rest of the petitioners present. Let them be able to, between anarchy in this country, arbitrariness, do not stand in accordance with the Constitution, then our country will fall into anarchy. And so, thank you.
Yes. In 1 minute, and I'm glad that you have signed, or rather to take it back to petition the miscellaneous criminal application. Application that your brother had placed before you for purposes of determination, if it will be in order to just include Kevin on the Inspector General as well as the rest of criminal investigations.
Yes.
We have been serving
Works.
Yes.
In my view, I do not find the statements recording, squaring out the proceedings before it. For one reason, my lord, that the petitioners' affidavits, those that were able to secure your lordship, the ordeals that they went through, who abducted them, and that's a process this court will be engaged in. This requires to put in supplementary affidavits to the affidavits from our clients' criminal justice system, which is completely as a separate proceedings, which are so unique in nature that we take to the stand. Because examining those individuals, we need to cross-examine within the limits of individuals for cross-examination. One of the individuals that I'm inviting is may be relevant in assisting the court to go to the depth of this matter. Number two, your lordship, is Minister from Government.
My lord, sorry, I know the court gave directions, but please guide us. On the side of the rest investigator who was brought by Mr. Nyamoti in the court, who will tell us the least amount of times, because beyond recorded may give leads which the police may want to follow. Those leads cannot be followed in one day. So we pray that on the part of the audits that release, which the petitioners have chosen to call production. Lord, I will not say so much, but I want to share with you a decision of the Supreme Court of this country. The state of Mwangi, Stephen Muriji, and the Abu Joan Mohammed SC, suing as the executrix of the estate of Honorable Daniel Toroitich Arap Moi, and was never fashioned to grant leave beyond release of a person from unlawful custody. The grant or denial of the writ does not deprive an. The matter ends, which I accept. To the question of the seventh petitioner, I urge you to agree with me and thank you.
I can hold somebody for 2 years, a year. That's the reason as to why 2010, the Constitution of Kenya made it very clear that if anybody's held means of the charge sheet, or a miscellaneous application for custodial days.
Yes.
If it extends to look for violations of my good brother, Owiti has put it very clearly, moves to investigations. My Lord, number two, look at the constellation of the officers before you, starting from the Inspector General of Police. Deals with intelligence becomes a subject matter on abductions. My Lord, I urge you to look at the scope, show that the DCI has the person who has not, that it is not released from police custody. None or anybody has produced evidence that they were released from a police station. They are, in this we are in the dark, my Lord. We urge that be a concern for every Kenyan. Not only the police. Is that somebody missing, already dead? Is that somebody missing in the hands of government agencies? That will take time. And that's why I agree with my brother, Mr. Nyamodi, that 14 days will be sufficient to bring to you a status report that the court can make a decision on.
Yes, my Lord. Your Lordship, of the seventh rescue. Perhaps I have listened and Lord, everybody seated at this bar, undermining the authority of this court and the orders that you issue. And perhaps for here for 2 days. Compliance with order number 3. That is the appearance of the inspector, having in mind that my lords, they are ex parte orders that have been issued by this honorable court. And for example, application of order number 3, that if the court maintains that it is Mr. Nyamodi is asking for, we hear the notice of motion application. So that, and my lord, bearing in mind that the enforcement of rights is under Article 25 of the 7th respondent, and we have filed a reply to that application, my lord. If you allow, can blast that application so that you are going to renew a ruling, because this is a court of record. So that within the requisite number of days we give findings based on the aspects that will be responded to. Therefore, to me, to my mind, I believe, without to underscore the importance of the matter before you, we still have the other miscellaneous application number 216.
Yes.
Where if, for example, orders of at least the respondent to look at the material that have been placed before and make an informed decision as either to the continuous appearance of. And I say that, my lord, with tremendous respect, because under Article 245 of the Constitution, by the first interested party, the second interested party, in terms of enforced disappearance, the Inspector General of Police, by the affidavit that have been filed, that yes. They are. What I foresee, my lord, is that given especially if at all one is alleged that the state actors are holding this person, the first respondent under Section 6 of, and the dispute ultimately will come to the judiciary for determination. My plea, my lord, we hear the notice of motion application.
Yes, my lord. Yes, my lord.
Yes.
Before I answer the question of time, its people, their rights, freedoms, property, other national interests. So, my lord, I would request that when you talk about the application for the release of this raid, that article to the end, and also look at Article 2. Who are listed there? So the application by the It is calling upon the duty bearers to perform their functions. And so the internal threat, police who are listed as the security organs, the NIS, and even the military, hence the way I've not had a law for me is Article 23, where applications for enforcement of rights, where the court hasn't given the power to, the power the court has been given under Article 23. The other thing, the power the court is. First of all, it will be a bit difficult to say that it's another problem. That these people don't deserve any time. It's not acceptable that the number 7 should be a day when it's not known where he is, and people are asking for time to investigate when the person on 24th. Because one of the people was abducted after leaving my office. I went and made a report about Quebec. Petitioner is not here. And the Inspector General of Police comes in person. Law enforcement. And then if you tell us why he cannot deal with that internal threat, that he answers salary.
Go Mr. Shio, Mr. Wanjiru, then
so that we can proceed effectively.
thank you. So very briefly, so go on time. It's a simple question.
And then the speaker to us so that we close this side. Now we associate to Mr. Milimani for a minimum of 14 days for practical and procedural reasons. The first respondent to investigate and at least have a progress report on that position that received only 1 day. Secondly, my lord, we would like to, for procedural propriety, flows from order number 1. Order number 1 presupposes it has now been established, and my lord cannot ignore this fact, that indeed,
They just say the days, you can give a very brief 30-second justification.
In accordance with the court's order, they were held for more days. The request to come back 14 days later is to every second in custody is an additional segment. It's a continuing violation of the right to be brought before a court of law by the court of these Kenyan citizens. Thank you, my lord.
Thank you. Mr. Kumar?
Just 1 minute. When the IG would be appearing in person, that is what the court angles. There have been no offer, none at all. Well, what we'd like to do is first to agree with the
Thank you, my lord. I agree. Order to appear before you must appear. And I argue that they don't need more time. And the 7th petitioner needs also to be set at liberty.
It's not on the question of time, but the directions you gave earlier that you be supplied with the documents that look like registration certificates. They do not look like documents that are and lastly, Your Lordship, perhaps the Director General should appear equally in person.
Chief Interested Party, my name is Milimani.
Yes.
On the issue of we suggest 1 day, I agree with my seniors, for reasons being Article 25, we adjourn, the longer he's in jeopardy. And that is a direct infringement on his right in terms of derogation of death, derogated in terms of the victims. So Your Honor will be paying for 1 day maximum.
stamped its authority, perhaps a move that led to his reproduction. No, my Lord, on the 6th day of January 2025, sorry, when my client was presented at 2 p.m. at Ngong Police Station. For that reason, I will wish to fully associate myself with the submissions made by my seniors at the bar. Still cries out loud for the court to help in the reproduction or the production of the 7th petition.
My Lord, may I just have 30 seconds running here on Friday for two simple reasons. The statements and the respondents have admitted that they have been going on with the investigations. So there is no need for keeping the email. My Lord, that is a right that cannot be limited in any manner whatsoever.
My Lord, if I may.
Yes.
I have not spoken to the first interested party.
Yes.
I think we associate ourselves fully.
Not obscure. The central question before the Apex Court was whether if you apply for habeas corpus, you cannot thereafter apply mystic, but in computation. The 2nd to 6th petitioner applicant. I understand that we're all eager for an expedited hearing process. I've heard persons say that think we can record statements this week. And Council Njiru mentioned supplementary affidavits. That's the other concern. This court must give sufficient time for the petitioner persons to too much time. It cannot be that because the 2nd to why the IG is important. I believe it was Council, I think it was Njiru last time, the 2nd and 3rd respondents have done, but also it has nothing more important, Mr. Nimodi, than dealing with what is perhaps and you will need to draft supplementary for the country, but to assist the 3rd respondent to coalesce all these statements. Perhaps we should try to make it easier. The rules and also discuss yes.
We are proposing 7 days.
Now, after and 2nd interested parties at a bare minimum, and perhaps the other interested parties would also want to, and 1st interested parties, and perhaps the 5th and 8th interested parties. Is that in order? Yes.
With regards to the current interested party.
Make those directions of joinder in chambers after this. I may join, I may not join. But there will be a contact person.
My Lord, a mere process of statement. And my Lord, I will renew the request that I Yes.
So the earliest we'll be able to come back is 23 days.
Yes, ma'am. If that is the amount of time they believe they need, then we let them be entitled to that. And we ask. No, it's okay.
7 days to close of business 15. The other 7 days will then take us to the 22nd. Propose the date. Council Mango.
If your Lordship is convenient.
So my Friday 24th is full. Physical or virtual?
Physical.
The earlier we start, the better. 9:30. I will give you a Dia could then give you a mention before me on the 24th, but I strongly suggest that you don't create a situation. And if on that...
just to request the court to bear in mind that should it be convinced to admit or that
I will not comment on the application.
My Lord.
Yes.
Will we be heard in opposition to counsel?
I don't want us to lose that here because for a matter of habeas corpus, I will not, I'll not give directions on your applications today, this Wednesday.
being the respondents. We are convinced and we have agreed that the application raised is very massive, but unfortunately we were not able to get to a settlement.
The joint, what I can assure you is, if I am convinced, I will join, but I will structure it in a way that we have a determination of those applications without starting. The application shall file and serve 2025. The respondents shall have leave to file and 22nd January 2025. To the 8th respondent, affidavit, Council Mango, we shall coordinate with petitioners, applicants. I am optimistic. Any of the respondents forwarded to the petitioner applicants. M, to confirm availability of a mention before this judge, exceptional, four exceptional circumstances. Completely beyond case management. Hearing of the attendance of the Inspector General of Police in person, officer, the same shall be, and for the avoidance doubt, seized and informed of the matters, previous directions, person in the alternative, corporate. At 9:30 a.m. time we should proceed. Of course, I do expect council to build consensus so that we're not having long drawn-out arguments. So, for example, if Sunday Courier is
online just to follow the proceedings, because some of us are going to be the follow-up and all, so we can just follow the proceedings but without any comments.
I thought I covered that.
Yes, yes.
I said
Requiring video assistance on that day.
to that form of mention.